At 10:51 on the morning of July 18, 2014, Dan Markel turned his car toward his home in Tallahassee. A Toyota Prius followed him. 4 minutes later, that same Prius was captured driving away. Dan Markel would never leave his house alive. Police soon discovered that the men connected to that car were not from Tallahassee. They had traveled hundreds of miles from South Florida. They did not work with Dan. They were not his friends. They were not his enemies. And investigators could find no reason either man should even know the 41-year-old law professor existed. Yet someone had followed Dan from his children's preschool, to his gym, and finally, to his home. So detectives were left with a question far more important than who had pulled the trigger. Who wanted Dan Markel dead badly enough to send strangers across Florida to kill him? The answer would take investigators through rental car records, surveillance footage, phone calls, unexplained payments, an undercover FBI operation, and eventually into the lives of people much closer to Dan than the men police believe carried out the killing. Before investigators could understand why two men from South Florida might have traveled hundreds of miles to Tallahassee, they first had to understand the man who had been targeted. His name was Daniel Eric Markel. Most people knew him simply as Dan. He was 41 years old when he was killed, and by that point he had built a life around two things that mattered deeply to him: ideas and family. Dan was raised in Toronto, Canada. Long before Tallahassee became his home, he had followed an academic path that took him through some of the world's most respected universities. He studied politics and philosophy at Harvard University, pursued graduate work in political philosophy at the Hebrew University of Jerusalem and the University of Cambridge, and later returned to Harvard for law school. At Harvard Law School, he served on the law review. His interests were never confined to simply practicing law. Dan wanted to examine what the law was supposed to accomplish. Why should society punish someone who commits a crime? What limits should exist on punishment? When should mercy matter? How should a justice system balance accountability with fairness? Those questions became central to his academic career. Before becoming a professor, Dan worked in Washington, D.C., at the law firm Kellogg, Huber, Hansen, Todd, Evans and Figel, where his work included white-collar criminal defense and civil litigation. He also clerked for Judge Michael Daley Hawkins of the United States Court of Appeals for the Ninth Circuit. Then, in 2005, Dan joined the faculty of the Florida State University College of Law. It was a significant move. Tallahassee would become his professional home. And over the next several years, Dan established himself within the legal academic community as a scholar focused heavily on criminal law and theories of punishment. Florida State described his scholarship as examining retributive justice and applying those ideas to subjects that included the death penalty, mercy, punitive damages, shaming punishments, and justice in societies recovering from mass atrocities. His articles appeared in publications including the Vanderbilt Law Review, Minnesota Law Review, and Harvard Civil Rights Civil Liberties Law Review. To people outside universities, some of those subjects might sound distant from everyday life. For Dan, they were anything but abstract. Punishment involved power. Justice involved limits. And criminal law raised a fundamental question that ran through much of his work. When the government punishes someone, what makes that punishment legitimate? At Florida State, his reputation grew quickly. After his death, his colleague Wayne Logan remembered him as a remarkably productive scholar who had reached full professor ahead of the usual schedule. Logan said Dan had developed a national and international reputation in the study of retributive theory. Dan's work also moved beyond academic journals. He wrote for publications including the New York Times, The Atlantic, The New Republic, and Slate. Florida State colleagues remembered him not only as a scholar but as a public intellectual who could take legal questions being debated inside universities and bring them to a much wider audience. He was also closely connected to other law professors around the country. Dan helped build an online community through Profsblog, a legal academic blog that became well known among professors and legal scholars. Florida State's own publications describe him as an active blogger years before academic blogging became routine. His professional life, then, was highly visible. His name appeared on academic papers. His ideas were debated by other scholars. His writing appeared in national publications. His colleagues knew exactly what kind of legal questions interested him. And after the shooting in July 2014, investigators would have to examine whether anything in that professional life could explain why someone wanted him dead. Had Dan angered someone through his work? Had one of his legal activities created an enemy? Was there a dispute investigators had not yet discovered? Those were reasonable questions when police were confronting the killing of a professor who had been deliberately followed to his home. But Dan Markel's professional achievements were only one part of his life. There was another part his family considered even more important. Dan was a father. He had 2 sons. When Dan was killed, the boys were only 3 and 4 years old. That fact changes the way his final morning looks when reconstructed years later. When Dan dropped his sons off at preschool on July 18th, he was not simply a law professor moving through a timeline that police would later examine. He was their father taking them where they needed to go. And for Dan's mother, Ruth Markel, his relationship with those boys mattered more than the degrees, publications, and academic recognition. More than 11 years after her son's death, Ruth sat with ABC News and reflected on what she remembered most proudly about him. It wasn't Harvard. It wasn't his professorship. It wasn't his publications. It was fatherhood. Ruth described Dan as a great father and said that, despite all his accomplishments, that was what made her proudest. There are also glimpses of that side of Dan in tributes left by people who knew him. After his death, Florida State University's law school community gathered to remember him. Students, colleagues, friends, and members of his family attended. The official tribute described a professor who had become deeply woven into the institution, academically and personally. That distinction matters, because true crime cases can eventually become dominated by evidence. Phone numbers, vehículos, court filings, bank records, recorded conversations, suspects, trials, sentences, and in the Dan Markel case, there would eventually be an enormous amount of all of it. But before any of those pieces existed in a police file, there was a 41-year-old father building a life in Tallahassee. There were classes to teach, articles to write, friends and colleagues to meet, and 2 small boys whose lives were closely tied to his. There was also a marriage that had already ended. Years earlier, Dan had met another lawyer named Wendi Adelson. Wendi had her own legal career. The 2 eventually married in 2006, had their sons, and obtained positions connected to Florida State University before settling in Tallahassee. Florida appellate records describing Wendi Adelson's later trial testimony confirmed that she and Dan married in 2006, had children, worked at Florida State University, and established their lives in Tallahassee. On paper, there were obvious similarities. Both were lawyers. Both were highly educated. Both were building careers. Both became parents. But their marriage did not last. Eventually, Wendi moved out of the family home on Trescott Drive. About a month later, she filed for divorce. The legal proceedings that followed became increasingly difficult. By 2013, the marriage itself was over. Dan Markel and Wendi Adelson were no longer husband and wife, but they remained connected by something no divorce decree could end: their children. For Dan, remaining actively involved in his sons' lives was important. For Wendi, there were decisions she wanted to make about what life after the divorce would look like. And soon, one of those decisions would bring the former couple back into court. At first glance, it was a family law dispute, the kind of conflict courts across America deal with every day after marriages end. There were lawyers, motions, arguments, a judge, 2 parents who no longer agreed about what should happen next. Yet after Dan's murder, investigators would return to those court records again and again, because the question facing police was no longer simply whether Dan Markel had professional enemies. They were now trying to understand every serious conflict in his life, and one dispute stood apart from the others. It concerned where his two sons would live. Wendi wanted something Dan would not agree to. She asked a judge to give her permission. The judge made a decision, and that decision meant that, even though the marriage between Dan Markel and Wendi Adelson had ended, the conflicts surrounding their family had not. What followed would eventually become one of the most important pieces of context in a murder investigation. Because when detectives began asking who might benefit from Dan Markel no longer being in Tallahassee, they would discover that the answer could not be understood without first examining a bitter fight over two young children. And that fight had reached far beyond Dan and Wendi themselves. By the time Dan Markel and Wendi Adelson's marriage officially ended, the question was no longer whether they would remain together. That had already been decided. The harder question was what would happen next. And at the center of it were their two young sons. Wendi wanted to leave Tallahassee. More specifically, she wanted to move with the children to South Florida, where much of her family lived. For Wendi, South Florida meant being closer to the people she had grown up around. Her parents were there. Her brother was there. The Adelson family's professional life was there. Tallahassee, by comparison, had become inseparable from a marriage that was ending and a custody arrangement that would continue tying her to Dan. There was only one major obstacle. Dan did not want his sons moved hundreds of miles away from him. And because they were parents sharing responsibility for the children, Wendi could not simply make that decision on her own. She went to court. The relocation dispute would eventually become one of the most carefully examined parts of Dan Markel's life after his murder. Court records show that Wendi sought permission to relocate with the boys from Tallahassee to South Florida. Dan opposed the request. His position was firm. If his sons moved south, maintaining the same kind of regular relationship with them would become far more difficult. The distance between Tallahassee and the Miami area is hundreds of miles. What had been ordinary parenting time could become long drives, flights, carefully arranged weekends, and school schedules. This was not a disagreement about where to spend a holiday. It would determine where the children grew up, and where their father fit into their daily lives. On June 20th, 2013, the court denied Wendi's request to relocate with the children. Court records later summarized in reporting and subsequent criminal proceedings confirmed that decision. The ruling meant the boys would remain in Tallahassee. For Dan, it meant they would remain close enough for him to continue being regularly involved in their lives. For Wendi, it meant the move she wanted could not happen with the children unless the situation changed. The divorce was finalized the following month, in July 2013. Yet finalizing the divorce did not end the disputes between them. Court records introduced years later described continuing disagreements over parenting, time-sharing, money, and other issues. And now another group of people becomes important to understanding what investigators would later examine: the Adelson family. Wendi Adelson came from a successful South Florida family. Her father was Harvey Adelson. Her mother was Donna Adelson, and her older brother was Charlie Adelson. Harvey and Charlie were dentists associated with the family's dental practice in South Florida. Court records from Charlie's later case identify the Adelson Institute as a family-owned dental practice associated with Harvey and Charlie. Donna was deeply involved in the family. And when the relocation dispute developed, the question of whether Wendi and her children would remain in Tallahassee did not concern Wendi alone. According to the Florida First District Court of Appeals 2026 opinion in Charlie Adelson's case, Wendi, Donna, Harvey, and Charlie all wanted Wendi to leave Tallahassee with the children and return to South Florida, where the family lived. That point would eventually matter to investigators. Because the court had said no, Dan continued to oppose relocation, and the family remained interested in finding a way for Wendi and the boys to move south. Emails exchanged between Wendi and Donna would later become evidence in the criminal cases that followed Dan's death. Those communications showed that the relocation question had not simply disappeared after the judge's ruling. One proposal was extraordinary because of the amount of money involved. Donna suggested that Wendi offered Dan $1 million in exchange for allowing the children to relocate to South Florida. The appellate record states that the proposed money would have come from members of the Adelson family. Dan did not agree to let the children move. Think about what that meant. The court had rejected relocation. A financial proposal large enough to change many people's lives had been discussed. And still, Dan's answer remained the same. His children were staying in Tallahassee. The significance of that disagreement would look very different after July 18, 2014. At the time, however, this was still a family law conflict. Parents disagree about relocation. Former spouses fight over custody. Grandparents become emotionally involved. Lawyers file motions. Judges decide what the law allows. None of those things, by themselves, establish involvement in a violent crime. That distinction matters. Because when detectives later examined this history, they were not entitled to assume that a bitter divorce meant someone had arranged a murder. They needed evidence. What the divorce records could give them was something more limited. They could show investigators where serious conflict had existed in Dan's life. They could show what people wanted. They could show what Dan had refused. And they could help detectives begin asking who, if anyone, might have considered Dan an obstacle. The conflict did not end with the relocation decision. As 2013 became 2014, Dan and Wendi remained locked in legal disputes, and Dan's concerns began to extend beyond Wendi herself. They reached Donna. Dan believed his former mother-in-law's involvement with the children had become a problem. According to reporting based on the court proceedings, Markel accused Donna of making disparaging remarks about him in front of his sons. That was particularly sensitive because the boys were still very young. Whatever disagreements existed between the adults, Dan did not want those conflicts being carried into his children's relationship with him. Eventually, he took the matter back to court. In 2014, Dan filed a motion seeking to restrict Donna Adelson's unsupervised contact with his sons. That motion was still unresolved when he was killed. And now the timeline becomes important. The marriage was finished. The relocation request had been denied. Dan had refused to allow the children to move to South Florida. $1 million proposal had been discussed. Legal disputes continued. And now another court fight was developing over Donna's access to the grandchildren. There was no murder investigation yet. There were no detectives studying telephone records. There were no rental car records being examined. No one was reconstructing the movements of a Toyota Prius. There was simply an increasingly complicated family dispute unfolding through lawyers and courts. For Dan, much of it came back to the same issue. His sons. He wanted to remain an active father. Moving them hundreds of miles away would change his relationship with them. He had successfully opposed that move once. And when he believed other family issues threatened that relationship, he went back to court. That is what the legal system was there for. Arguments were presented. Motions were filed. Judges made decisions. The next hearing could bring another ruling. Then, on July 18, 2014, the legal battle stopped in the most permanent way possible. Dan Markel was shot in his garage. He died the following day. And almost immediately, circumstances that had once belonged inside a family law file took on a completely different significance. Detectives now had to work backward. Who had conflict with Dan? Who had reason to resent him? Who might benefit if he were no longer able to oppose decisions involving his children? What cases were currently pending? What had Dan been fighting for? And what would change because he was dead? Those were investigative questions. They were not conclusions. And that distinction would remain important throughout a case that eventually involved multiple defendants, multiple trials, and years of litigation. A custody dispute could suggest a possible motive. It could not identify the person who entered Dan's garage. A rejected relocation petition could explain why emotions were high. It could not explain how a killer reached Tallahassee. An argument over the grandchildren could provide context. It could not tell detectives who had fired the weapon. Police still had to find the people responsible. And in those first hours, investigators had several possibilities to consider. Dan was a law professor whose writings dealt with criminal justice. Could his work have made someone angry? Could a professional disagreement have become personal? Could the shooting have involved someone from his private life? Was there another conflict police did not yet know about? They could not simply choose the explanation that appeared most dramatic. They had to follow evidence. And evidence from a targeted killing can begin with details so ordinary that most people would never notice them. A traffic camera, a rental agreement, a telephone number, a toll transponder, a vehicle appearing at the wrong place at the right time. Investigators began reconstructing Dan's final morning. They knew he had dropped his sons off at preschool. They knew he had gone to the gym. They knew he had returned home. So detectives started looking at what existed around those movements.
There it is.
Video,
Prius.
traffic, vehicles, anything that might show whether Dan had been alone during the final hour of his life. And there was one vehicle that kept appearing. It was not Dan's car. It did not belong to anyone investigators initially expected to find. It was a light green Toyota Prius. Surveillance would eventually show that the vehicle had been near Dan as he moved through Tallahassee on the morning he was shot. At the gym, on the road, and near the neighborhood where he lived. For detectives, that Prius offered something the divorce records could not. Movement, a physical trail, something they could trace. And once they began following it, the investigation started moving away from court filings in Tallahassee and toward South Florida. The family dispute had given police possible context. The Prius was about to give them their first path toward the men who had come to kill Dan Markel. And when investigators finally learned who those men were, they would encounter a problem that made the case even more difficult. Neither man appeared to have any personal reason to want Dan dead. So why had they come to Tallahassee? And who had pointed them toward Dan Markel? Friday, July 18th, 2014 began with Dan Markel doing something he had done many times before. He was taking care of his sons. That morning, Dan left his home on Trescott Drive in Tallahassee and drove the two boys to preschool. They were still very young. One was 3. The other was 4. Nothing about that responsibility suggested that within a few hours, detectives would be reconstructing every mile Dan had traveled that morning, looking for the moment when someone else had entered his route. Investigators would later establish that Dan dropped the boys off shortly before 9 o'clock. Then he continued with his morning. His next destination was Premier Health and Fitness Center on Maclay Boulevard. At approximately 9:12 a.m., Dan's vehicle entered the parking area of the gym, and another vehicle appeared there too, a light green Toyota Prius. At that moment, of course, there was nothing inherently suspicious about a Prius entering a parking lot. It was simply another car. Dan went inside. The Prius remained in the area. Later, investigators would obtain surveillance footage from the gym and combine it with recordings from other cameras across Tallahassee. Those images would allow detectives to reconstruct movements that no one watching them in real time had reason to remember. Dan completed his workout. At around 10:38 that morning, he left Premier Health and Fitness Center. The Prius left too. And once Dan began driving toward Thomasville Road, the other vehicle remained close. Later, when investigators watched the surveillance recordings, the pattern became difficult to dismiss. The Prius had appeared when Dan arrived at the gym. It was there when he left. And now it was moving along the same route as him. Dan continued toward home. The car followed. There was no police officer watching any of this happen. No detective was tracking Dan in real time. No one had yet reported a crime. The significance of those movements would only become clear after the morning was over. At roughly 10:51 a.m., Cameras mounted on Tallahassee city buses captured Dan's vehicle traveling along Thomasville Road. The Prius appeared nearby. Dan turned left toward Benton Road, taking him back toward the neighborhood where he lived. The Prius followed the same direction. Investigators would later use those bus recordings to narrow the time of the shooting to an exceptionally small window. At approximately 10:51, the Prius was still traveling toward Dan's neighborhood. At approximately 10:55, another bus camera captured what appeared to be the same Prius traveling north on Thomasville Road away from the area. 4 minutes. Somewhere inside that 4-minute window, investigators believed Dan Markel had been shot. Dan reached his home on Tracecott Drive in Benton Hills. It was the house where he had lived during his marriage. Now he lived there without Wendi. The garage door opened. Dan drove inside. What happened next would eventually be reconstructed through physical evidence, witness information, surveillance footage, and testimony produced years later in court. Dan was still sitting in his vehicle inside the garage when he was shot twice in the head. Florida's First District Court of Appeal would later summarize the central fact simply. Markel was sitting inside his car in his home garage when he was shot twice. The attack was brief. There was no prolonged confrontation documented at the scene. There was no attempt to steal Dan's vehicle. The person who had come there had accomplished what police would soon believe was the purpose of the visit. And then the vehicle that investigators would spend months trying to identify was gone. A neighbor heard the gunfire. At 11:02 a.m., Tallahassee police received the 911 call. When officers reached the Tracecott Drive home, they found Dan inside his vehicle in the garage, critically wounded. The garage door remained open. Dom was alive, but his injuries were devastating. Emergency personnel transported him to the hospital. He would not recover. Dan Markel died the following day, July 19, 2014. He was 41 years old. For his family, his colleagues, and everyone who knew him, those hours were about whether Dan could survive. For police, another process had already started. They needed to know what had happened inside that garage. They needed to know whether Dan had interrupted a burglary, whether someone had followed him home, whether the shooting had emerged from a personal confrontation, whether his work had brought him into conflict with someone, whether there was something in his private life investigators had not yet found, and, above all, whether the gunman had selected Dan specifically. By July 21st, Tallahassee police were publicly saying that investigators believed Markel had been deliberately targeted. That changed the questions immediately. If this had not been random violence, then someone had wanted this particular man dead. Why? Dan was a law professor. Did the answer involve his professional life? He wrote and taught about criminal law and punishment. Had someone become angry with him because of his work? Did the answer involve someone he knew personally? A former client? A colleague? A stranger with some grievance investigators had not yet discovered? Or did it have something to do with the bitter legal disputes that had followed his divorce from Wendi Adelson? At that stage, investigators could not responsibly choose one explanation and ignore the others. A targeted killing was only the beginning of the problem. They still needed motive. They still needed a gunman. And they needed evidence connecting those things together. Within hours of the shooting, detectives began speaking to people who knew Dan. One of the most important interviews that day was with his former wife, Wendi Adelson. Wendi did not initially walk into that interview knowing exactly what had happened to Dan. Video later released from the police interview showed an investigator telling her that there had been a shooting at Dan's home and that his condition was grave. The interview would continue for more than 5 hours. Police wanted to understand Dan's life. They wanted names, relationships, disputes, anyone who might have been angry with him. Anything unusual that might explain why someone would shoot a law professor in his own garage in the middle of the morning. And during that conversation, Wendi volunteered a detail detectives could hardly ignore. It involved her brother, Charlie Adelson. Wendi told investigators that Charlie had once made a joke involving Dan. Charlie had given Wendi a television as a divorce gift. According to what Wendi told police, Charlie had joked that buying the television was cheaper than hiring a hitman. The Florida First District Court of Appeal specifically recorded that statement in its July 2026 opinion reviewing Charlie Adelson's conviction. The court noted that hours after the murder, when police interviewed Wendi, she told investigators about the joke. 4 detectives sitting in that interview room on the day Dan had been shot. It was an extraordinary thing to hear. But it was not proof. People make inappropriate jokes. A comment made during a bitter divorce does not establish that the speaker later arranged a murder. Investigators could not turn a remark into a homicide case simply because the remark sounded disturbing after the fact. They needed to determine whether Charlie's comment had any relationship to what had happened on Trescott Drive. And Wendi herself described it as a joke. Years later, she would continue to deny that she was involved in Dan's killing. Court records from subsequent proceedings document those denials. Still, detectives had to record what she had told them. They now knew there had been an intense custody dispute. They knew Dan had prevented his sons from being relocated to South Florida. They knew litigation between Dan and Wendi had continued after the divorce. They knew Dan had sought restrictions involving Donna Adelson's unsupervised access to the boys. And now, within hours of the shooting, Wendi had told them her brother had once joked about hiring someone to kill Dan. Those were pieces of information, not yet a case. What police still did not have was the person who had actually entered Dan's garage. They did not have a name for the shooter. They did not have an established connection between any member of Wendi's family and whoever had been at Dan's home that morning. They did not have a payment. They did not have a confession. They did not have a complete chain of communications. And they did not yet know that solving the case would eventually require them to connect individuals living hundreds of miles apart. At that moment, the investigation was still centered on Tallahassee, on a garage, on a wounded professor, on a family history investigators were only beginning to understand, and on something captured by cameras that had no idea they were recording evidence. The Prius. Police began collecting surveillance footage, not just from one camera, from multiple locations. The gym, city buses, roadways, places Dan had passed on the final morning of his life. When investigators began putting those recordings in sequence, the Prius stopped looking like a vehicle that had simply happened to be nearby. The 2026 appellate court described what law enforcement ultimately established. Surveillance from multiple sources showed a rental car following Dan as he drove to his son's school, then to the gym, and finally back home. That was crucial, because a vehicle that appeared near the crime scene might be a coincidence. A vehicle seen near someone's home could belong to a neighbor. A car caught on one camera could mean almost anything. But this vehicle appeared across Dan's morning, at locations separated by time and distance. When Dan moved, the Prius moved. When Dan left the gym, the Prius left. When Dan headed toward Benton Hills, cameras recorded the Prius traveling behind him. Then, within minutes of the shooting, the Prius was recorded heading away. Now investigators had something physical to pursue. They examined the car carefully. It appeared to be a Toyota Prius from approximately the 2006 to 2009 model years. Its color was unusual enough to help narrow the search. Toyota called the color silver pine mica, a shade that could appear metallic or light green depending on the lighting. Its windows were darkly tinted, but there were more specific details. The vehicle appeared to be missing a tow bolt cover on the driver's side of the front bumper. The passenger side mirror housing was black, while the driver's side mirror matched the color of the car. And investigators could see what appeared to be a toll transponder mounted in the center of the windshield. Those details were important because thousands of people drove Toyota Priuses. Far fewer drove one with that exact combination of characteristics. There was another reason the toll transponder interested law enforcement. The FBI later noted publicly that SunPass was particularly common in South Florida. It wasn't proof that the vehicle had come from there, but it was another detail worth following. The case now had two very different trails. One trail led backward through Dan's personal life, the divorce, the children, the relocation fight, the pending court disputes, the people who knew him, the comment Wendi had told police about during her interview. The other trail had nothing to do with court filings. It was mechanical. A car, a color, a missing piece from a bumper, a mismatched mirror, a toll transponder, a series of surveillance recordings, and detectives did not yet know where the second trail was going to lead. The important question was no longer simply whether a Prius had been near Dan's house. Investigators needed to know who had been inside it. Was the driver local? Was the vehicle privately owned? Had it been borrowed? Had it been rented? Where had it been before July 18th? Where did it go after the shooting? And was there anything linking the person who used that car to Dan Markel? The farther detectives followed those questions, the stranger the case became. Because the vehicle had a history. It had paperwork, and paperwork produces names. Investigators would eventually trace the Prius away from Tallahassee, hundreds of miles away, towards South Florida. And when they finally identified the men associated with it, they would discover something that created an entirely new problem. Dan Markel did not appear to know them. They weren't his colleagues. They weren't friends. They weren't relatives. Investigators could find no personal relationship that explained why those men would have been following a Florida State University professor through Tallahassee on the morning he was killed. Finding the car was beginning to answer one question, but it was about to create a much larger one. If the people inside that Prius had no reason of their own to kill Dan Markel, who had given them one? According to testimony later presented in court, investigators traced the Prius to a Miami area rental agency. The rental agreement showed that the car had been rented to Luis Rivera and included contact information. Another telephone number listed on the paperwork would lead investigators to Sigfredo Garcia. Two names. For the first time, investigators were moving beyond the image of an unidentified Prius. Luis Rivera. Sigfredo Garcia. Neither man lived in Tallahassee. Both were from South Florida. The geographic distance immediately raised another question. Why would men from the Miami area have been driving through Dan Markel's neighborhood on the morning he was murdered hundreds of miles away? Police could not answer that by looking at a rental agreement. So they turned to another form of evidence. Cell phone records. A mobile phone does more than place calls. When it communicates with a cellular network, records can sometimes help investigators determine the general area in which that phone was operating. Those records do not function like a perfect GPS map showing every step a person takes, but combined with other evidence, they can become powerful. Investigators began examining the phones associated with Garcia and Rivera. The records gave them another way to test the Prius theory. If the rental car had traveled from South Florida to Tallahassee, did the phones associated with the men investigators were examining make the same journey? According to Tallahassee police records later made public, they did. The investigation showed Garcia and Rivera traveling from the North Miami area toward Tallahassee during the period leading up to the murder. The Prius connected to the crime had been rented in North Miami on July 15, 2014. Police said Garcia and Rivera traveled north on July 16th. Cell records indicated that by shortly after midnight on July 17th, their phones had reached Tallahassee, and phone records placed them in areas relevant to the investigation, including the vicinity of Markel's home and the gym. The car and the phones were beginning to tell the same story. The Prius moved north. The phones moved north. The Prius appeared around Dan's route. The phones were in Tallahassee. Then investigators found evidence of where the men stayed. A witness told police that he had helped Garcia and Rivera obtain a motel room on North Monroe Street in Tallahassee on the night before Dan's murder. That placed the two men in the city before the shooting. And the following morning, the Prius appeared behind Dan. Police now began reconstructing the sequence in far greater detail. Dan dropped his boys at preschool. He went to the gym. The Prius followed. Dan exercised for more than an hour. The Prius waited. Dan left. The Prius followed again. City bus cameras recorded it moving behind him toward Bedden Hills. Dan reached Trescott Drive. Minutes later, he was shot. Then cameras captured the Prius moving away from the area. Taken individually, each piece had limitations. A cell phone tower does not prove exactly what a person is doing. A rental document does not prove who is behind the wheel every second the vehicle is on the road. A surveillance camera may capture a vehicle without capturing the occupants clearly enough to identify them. A toll record only establishes another point in a journey. But investigators were not relying on any one piece. The strength came from the overlap. Rental records, telephone records, toll information, surveillance, witness accounts, geography, timing. When those records were placed together, they allowed detectives to reconstruct movements that had taken place before anyone knew a crime was about to occur. And there was still more. Investigators began looking backward from July. They wanted to know whether this was Garcia and Rivera's first trip to Tallahassee. The answer would become one of the most important discoveries in the case. It wasn't. Evidence presented later in court established that Garcia and Rivera had traveled to Tallahassee once before. The earlier trip took place in June 2014. Weeks before Dan was murdered. Florida appellate records described that first trip as occurring between June 2nd and June 5th. The records later showed a cluster of telephone communications during that period, and Luis Rivera eventually testified that he and Garcia had come to Tallahassee intending to kill Dan Markel but lost track of him while following him. That evidence completely changed the meaning of the July journey. The trip connected to the murder was no longer an isolated drive from South Florida to Tallahassee. There had been an earlier visit, a previous attempt. According to Rivera's later testimony, the two men had arrived in Tallahassee during that June trip with something remarkably specific: a piece of paper. On it was Dan Markel's photograph and his address. Rivera testified that he and Garcia tried to follow Dan, but lost him. Police would eventually hear those details after Rivera began cooperating. But even before the entire account was available to investigators, the documentary evidence surrounding the two trips was beginning to expose planning. These were men who lived hundreds of miles from Dan, yet they had traveled to his city more than once. Their movements brought them into the areas associated with him. And on the second trip, surveillance recorded the Prius following him through his final morning. The first trip also provided investigators with another opportunity to examine communications. Phone records could be viewed not simply as a list of calls, but against significant moments. When was a car rented? Who communicated immediately afterward? When did the phones begin moving north? Who contacted whom while the men were in Tallahassee? When did those communications change? Years later, prosecutors would present that type of analysis to juries. One Tallahassee police expert described what investigators called rapid call turnarounds, one person ending a call and then immediately contacting another person connected to the case. During the June 2 to June 5 trip alone, later court records documented repeated communications among people investigators would eventually place within the broader conspiracy. But at this stage of our story, detectives had not yet proven what those communications meant. A telephone call tells you two numbers connected. It does not automatically tell you what was said. That distinction was essential. Investigators had to resist the temptation to make the records say more than they actually did. What they could establish was movement and patterns. Garcia and Rivera had come north. Then they had gone home. Weeks later, they came north again. The second journey began shortly before the killing. According to the Tallahassee Police Department's timeline, The Prius tied to the murder was rented in North Miami on July 15th. The next day, July 16th, the men began traveling north. Their cell phones indicated they reached Tallahassee shortly after midnight on July 17th. They remained in the area. Then came the morning of July 18th. The gym, the surveillance cameras, the bus videos, Benton Hills, the garage, and afterward, the journey reversed. South, back toward Miami. Investigators could trace the Prius through toll information. They could compare that movement with telephone activity. They could examine when phones were active and when they were not. The records were beginning to create a timeline extending hundreds of miles across the state. And there was a detail about Sigfredo Garcia that would become especially significant. When investigators eventually interviewed Garcia on May 24, 2016, nearly 2 years after Dan's death, Garcia denied ever having been in Tallahassee. He said he had never traveled there with Rivera. He denied knowing anything about Dan Markel's homicide. But police had already spent years assembling records pointing in the opposite direction. The rental documents placed a phone associated with Garcia on paperwork connected to the Prius. Cell phone records tracked the relevant phones north. Surveillance placed the Prius along Dan's route. Witness information placed Garcia and Rivera in Tallahassee. And there had been an earlier June trip. The investigation was reaching an important threshold. For nearly 2 years, the public had known mostly about an unidentified Prius. Now police believed they knew who had been associated with it. On May 25, 2016, one day after investigators questioned him, Sigfredo Garcia was arrested in South Florida on a first-degree murder charge in connection with Dan Markel's death. The following month, court documents identifying Luis Rivera as another suspect became public. A Leon County grand jury would indict both men. For Dan's family, it was a major development. For investigators, it was also only part of the answer. They had spent almost 2 years trying to put names inside the car. Now they had them. Sigfredo Garcia, Luis Rivera. Police believed the men had driven hundreds of miles to Tallahassee. They believed the two had watched Dan. They believed the Prius had followed him. They had records showing the journey. And later testimony would place Garcia as the shooter and Rivera behind the wheel during the attack. Rivera would ultimately plead guilty to second-degree murder and cooperate with prosecutors, while Garcia would later be convicted of first-degree murder. That should have answered the central question: who killed Dan Markel? But instead, identifying Garcia and Rivera exposed another problem. A problem investigators could not explain simply by tracing the Prius. Why Dan? Police began looking for any direct connection between the professor in Tallahassee and the men they had identified in South Florida. Had Dan represented either man? Had he taught either of them? No. Were they colleagues? No. Friends? No. Relatives? No. Did they have a personal dispute with him? Investigators could find no evidence of one. The Tallahassee Police Department would later state that Garcia and Rivera had been enlisted to kill someone they did not know and had never interacted with before the murder. That changed the nature of the case. If the men connected to the Prius had not killed Dan because of anything between Dan and them personally, then investigators needed another explanation. Someone had to know Dan. Someone had to know where he lived. Someone had to know enough about his life for two men from South Florida to locate him in Tallahassee. According to Rivera's later testimony, he and Garcia had possessed Dan's photograph and address during their earlier trip. Where had that information come from? And there was another question. Money. Why would two men drive nearly the length of Florida, more than once, to kill a stranger? What were they supposed to receive in return? Police had reached their first major breakthrough. The Prius was no longer unidentified. The journey was no longer unexplained. The men believed to have carried out the killing now had names. But a murder-for-hire case cannot end with identifying the people at the bottom of the chain. Investigators needed to know who stood above them. And when detectives examined the relationship surrounding Sigfredo Garcia, one connection began to matter more than the others. It led to a woman who knew Garcia extremely well. A woman who had also been involved with someone much closer to Dan Markel's former family. Her name was Catherine Magbanua. And once investigators understood where she fit, two worlds that had appeared completely separate, the men in the Prius and the bitter dispute surrounding Dan Markel, were about to intersect. According to the appellate court's later summary, Rivera said that he, Garcia and Magbanua were paid $100,000 total for killing Markel. Then came a detail so specific that investigators paid close attention to it. The payment, according to the evidence summarized by the court, was made in $100 bills. But the bills were not simply loose inside a bag. They were grouped together, stapled. The $100 bills had been stapled into increments of $1,000. That meant 10 $100 bills, stapled together. Then another 1,000, and another, and another. It was an unusual way to organize large amounts of cash. And investigators discovered that this detail had significance outside Rivera's account. According to the appellate court, investigators learned that Charlie Adelson habitually kept his money stapled together in that same manner. For detectives, that was the kind of detail that deserved close examination. Not because stapling money identifies a murderer. It does not. Anyone can staple currency. There is nothing exclusive about the practice. But in an investigation based on overlapping pieces of evidence, unusual habits can matter when they appear in more than one place. Rivera described a payment. The payment had a particular physical characteristic. Investigators then found evidence that a person connected to Catherine Magbanua had a habit consistent with that characteristic. It was another point of comparison. And now the financial investigation was expanding. There was the large cash payment Rivera described. There were the payroll checks that began going to Catherine after the murder. There was Catherine's relationship with Charlie. There was her continuing connection to Garcia. There was Rivera's account of who recruited whom. And there was a timeline. Before the murder, the men traveled. After the murder, money moved. Investigators started examining that sequence carefully. Because in a murder-for-hire investigation, the timing of money can be as important as the amount. Was money withdrawn before the killing? Was it delivered afterward? Did someone's financial circumstances change? Were there payments that could not be easily explained by legitimate work? Were people receiving money from individuals or businesses with whom they had no ordinary employment relationship? And did those payments align with the relationships investigators had already uncovered? This was the point at which the case began changing shape. For nearly 2 years, the central public mystery had been: who killed Dan Markel? The Prius had helped investigators move toward an answer. Sigfredo Garcia. Luis Rivera. Police now had men they believed had traveled to Tallahassee and participated in the killing. But Rivera's cooperation forced investigators to ask a different question. Who hired them? That question moved the investigation upward. The person who pulls a trigger in a murder-for-hire case is not necessarily the person who wanted the victim dead. The driver is not necessarily the person who chose the target. And the person who recruits the killers may still be acting for someone else. If Rivera was telling the truth, there had been a chain. Someone wanted Dan dead. That desire had to reach someone capable of arranging it. The request had to move from one person to another. Information about Dan had to be provided. Garcia and Rivera had to know where to travel. They had to know whom they were looking for. And someone had to be prepared to pay when the job was completed. This brought investigators back to one of the most important details from Rivera's later account. During the earlier June trip, Rivera said he and Garcia already had information identifying Dan. They had his photograph. They had his address. That meant someone had supplied enough information for two men who did not know Dan personally to travel to Tallahassee looking for him. And now Rivera was saying there was also $100,000 attached to the job. The question was no longer simply how Garcia and Rivera had found Dan. It was where the information and money originated. Catherine Magbanua appeared to occupy the same position in both directions. On one side was Sigfredo Garcia. On the other was Charlie Adelson. That did not automatically establish what Catherine told either man. But Rivera's account gave investigators a theory they could test. According to him, Magbanua recruited Garcia.
Garcia recruited Rivera.
And a payment followed the killing. Investigators now had to determine whether Magbanua herself had merely connected people or whether she had knowingly participated in arranging the murder. And if she had participated, another question followed immediately. Who was directing her? The payroll evidence became more important in that context. 2 months after Dan's death, Catherine was receiving a salary from the Adelson dental practice. The Florida Appellate Court later stated that investigators found no evidence she actually worked there. During the 2019 prosecution of Magbanua and Garcia, prosecutors emphasized the financial records and asked why the Adelson Institute would be paying Catherine if she was supposedly Charlie's personal assistant. The state argued that the payments helped demonstrate the financial relationship it believed existed after the murder. Magbanua's defense disputed the prosecution's interpretation of the evidence. That disagreement is important. The evidence did not arrive with labels attached. A check does not say, "Payment for murder." A phone record does not tell investigators what was discussed. A bundle of cash cannot identify its previous owner merely because of how it was arranged. Detectives and prosecutors had to assemble context. Then the defense had the opportunity to challenge that interpretation. Ultimately, juries would have to decide whether the pieces established guilt beyond a reasonable doubt. But long before those juries were selected, investigators were dealing with the practical problem of building the case. And Rivera's cooperation gave them far more than another name. He gave them an alleged structure. According to the account summarized by the appellate court, Catherine Magbanua approached Sigfredo Garcia.
Garcia approached Luis Rivera.
Garcia and Rivera traveled to Tallahassee. Dan Markel was killed. And Rivera said $100,000 was paid for the murder. Now investigators could compare that story with everything they already possessed. Did Garcia and Rivera actually travel to Tallahassee? Yes. The records supported that. Was there an earlier trip? Yes. Did they follow Dan on July 18th? Surveillance supported that conclusion. Was there a rental vehicle? Yes. Did Catherine connect Garcia to Charlie Adelson? Yes. Did money begin flowing from the Adelson dental practice to Catherine after Dan's death? According to the appellate record, yes. Was there evidence concerning unusually bundled cash? Yes. Each answer reduced the number of coincidences investigators would have to accept if Rivera's account were false. But there were still gaps. A murder-for-hire conspiracy involving several people rarely produces a single document describing the entire plan. No contract had been discovered with everyone's name printed across the top. No recorded meeting from before the murder had surfaced in which every participant sat together and openly discussed killing Dan. Investigators were reconstructing the alleged agreement from what people did before the murder, what they did afterward, who communicated with whom, where they traveled, and where money moved. And there was another challenge. Even if Rivera could help prove the roles of Garcia and Magbanua, prosecutors still faced the question of what evidence could reach farther up the chain. A cooperating killer's accusation alone could be attacked. Financial evidence could be interpreted in competing ways. Relationships could be dismissed as coincidence. Investigators needed something that would reveal how the people they were examining behaved when they believed someone outside the conspiracy knew what had happened. That opportunity would eventually come. Not through another traffic camera. Not through another rental agreement. and not through another search of old divorce records. It would come from the FBI. Investigators would create a new event themselves. They would approach a member of the Adelson family with a carefully designed message connected to Dan Markel's murder. Then they would watch. Who would that person call? Who would those people contact next? What would they say when they believed someone was demanding money because of what happened in Tallahassee? For the first time, investigators would not merely be reconstructing events from years earlier. They would create pressure in the present and record the response. The operation became known as the bump. And what happened after that approach would give investigators access to conversations they had spent years trying to understand. By 2026, the Dan Markel murder case had produced 5 convictions. Luis Rivera had admitted participating in the killing. Sigfredo Garcia had been convicted. Catherine Magbanua had been convicted. Charlie Adelson had been convicted. And Donna Adelson had been convicted. Florida's First District Court of Appeal summarized the legal result in its July 1, 2026 decision, in the 12 years since Dan Markel's murder. 5 defendants had been charged, convicted, and sentenced for their roles in the plot to kill him. Those convictions establish criminal responsibility for the people juries found guilty, but they do not give investigators or anyone watching this case permission to turn suspicion into fact. And that distinction is especially important here. Throughout the investigation, another name appeared repeatedly: Wendi Adelson. Wendi was Dan Markel's former wife. Their divorce and the fight over whether their 2 sons could be moved from Tallahassee to South Florida became central to prosecutors' explanation of motive. She was Donna Adelson's daughter. She was Charlie Adelson's sister, and she testified during proceedings connected to the case. But Wendi Adelson has not been charged with Dan Markel's murder. She has denied involvement. The Associated Press reported during Donna Adelson's 2025 trial that both Wendi and her father, Harvey Adelson, had denied involvement and had not been charged. That remains a critical boundary. A person can appear in phone records without being guilty of a crime. A person's relationship with someone who has been convicted does not transfer guilt to them. A bitter divorce does not prove murder. A family dispute does not prove conspiracy. And testimony that mentions a person is not the same thing as a criminal charge, much less a conviction. The evidence concerning Wendi has been discussed publicly for years. She gave police a lengthy interview on the day Dan was shot. She told investigators about Charlie's earlier hitman joke. Her relocation dispute with Dan became part of the prosecution's theory in later trials. She testified under immunity in multiple proceedings. But none of those facts changes her legal status. She has denied participating in Dan's murder and has not been charged. The same caution applies to Harvey Adelson. Harvey was Donna's husband and Charlie and Wendi's father. He traveled to Miami International Airport with Donna in November 2023 when she was arrested before the couple could board their international flight. But Harvey was not arrested for Dan Markel's murder. He has denied involvement and has not been charged. Those facts matter because a responsible account of this case has to distinguish among 3 very different categories. What investigators suspected, what prosecutors alleged, and what juries actually found beyond a reasonable doubt. For Luis Rivera, Sigfredo Garcia, Catherine Magbanua, Charlie Adelson, and Donna Adelson, the criminal process resulted in convictions. For Wendi Adelson and Harvey Adelson, it has not. And whatever theories may circulate outside the courtroom should not be presented as established fact. What the case does establish is already extraordinary enough. Investigators began with a professor shot inside his garage. The men eventually connected to the killing appeared to have no personal relationship with him. Police then reconstructed an enormous chain of evidence. They followed a Toyota Prius through surveillance footage. They connected that vehicle to South Florida through rental and toll records. They examined cell phone data. They discovered an earlier trip to Tallahassee. They connected Sigfredo Garcia to Catherine Magbanua. They connected Magbanua to Charlie Adelson. They followed money. They obtained Luis Rivera's cooperation. They created the FBI bump. They monitored the reaction. They recorded conversations. And years later, they returned to one of those recordings with improved audio processing. That accumulation eventually became the basis for prosecutions that reached far beyond the two men who traveled to Tallahassee. The remarkable part of the Dan Markel investigation was not that detectives found one perfect clue. They didn't. It was that dozens of pieces that initially seemed separate began supporting one another. The Prius explained movement. The rental records helped identify people. The phone records showed communication patterns. The relationships explained how people from different parts of Florida could be connected. The financial evidence helped prosecutors argue that the killing had been paid for. Rivera gave investigators an insider's account. The undercover operation tested how the suspected network reacted under pressure. And the recorded conversations gave prosecutors another body of evidence to place before juries. That is what the criminal cases ultimately established. Not every rumor, not every theory, not every suspicion that has circulated since 2014. The convictions establish responsibility for 5 people. Beyond those convictions, the line between evidence and speculation still matters. Because after 12 years of investigations, court hearings, testimony, recordings, and appeals, the strongest way to tell Dan Markel's story is not to invent one final mystery. It is to recognize what investigators actually proved, and then return to the person whose life existed long before any of those defendants became names in a murder case. Dan Markel, a law professor, a son, a brother, a friend, and, above everything his mother remembered most proudly, a father to 2 young boys. The criminal cases tell us how investigators reconstructed the plot that ended his life. But the final word in this story should not belong to the people convicted of killing him. It should belong to the life that was taken. Which part of this investigation do you believe proved most decisive? The surveillance trail, the phone records, Luis Rivera's cooperation, the financial evidence, or the FBI's undercover operation? Let me know in the comments. And if you value carefully researched true crime documentaries that follow the evidence without turning speculation into fact, subscribe for the next case.